everybody. We're ready to start with the next panel. The first panel is a discussion on building an IP portfolio if and when patent protection makes sense. And this panel was, the idea for this panel came up from Louisa, who is all the way over on the right of the stage, Louisa Salomon, who's patent counsel for Johns Hopkins Technology Ventures. And I invited her to speak and asked her what she thought would be a good topic. And she said, well, I would really like to hear people talk about whether you should be getting a patent and on what, particularly given the patent eligibility debates and those issues in the Federal Circuit being friendly to some patents and not friendly to others. So I decided to put her on that panel. And we built the panel around that. So let me introduce the other speakers, and I'll also ask you guys to fill in some blanks to let people know a little bit more about your background. But starting on the other side of the stage, we have Michael Nye, who's co-chair of the Intellectual Property Practice Group at Miller, Johnson, Shell, and Chiminski. Did I say that right? Probably.
Miller Johnson is fine.
Miller Johnson, and Michael was recommended by Randy, who's going to be on the next panel, I think, or later on today. Then we also have Justin Mullen, who is senior counsel at Capital One. Thank you for coming. And last but certainly not least is my friend Savone Kalmanoff, who's director of intellectual property at Canon USA. And so let's start with, I guess, a wide open question. And you guys can take it wherever you want. And feel free to also weave in a little bit more about your background if you want, so that people can know, what angle from which you come. But when you hear the topic, should I even get a patent? And if so, on what? And maybe even where? Big topic, but what's the first thing that comes to mind? And Louisa, since this panel was your idea, maybe we'll start with you, and you can kind of define those thoughts, if you would.
Of course, that is a big question, and I think that, especially in the university space, it's a question that we have a lot of parameters around. I think for me, because my background is in biomedical engineering, and a lot of the technologies that I see at Hopkins are really a little bit of everything. But I also deal with our software technologies quite frequently. I think for us, it's both looking at what is the runway for this potential product. Is it something that we're going to be seeing in the market in the next year or two? Or is it going to be, something attached to perhaps a medical device or an imaging system that isn't going to come into the market for another 10 years? And those are, really big challenges for us. We certainly don't have a crystal ball. And so knowing when to pull the trigger on a patent application can be especially challenging, because we're dealing with more than just, can we push this through the patent office? Would the Federal Circuit uphold this application if it went before the court? So that's why I wanted to hear from everyone too, because I think we're always learning, looking for tools and tactics.
Yeah, great. Let's go to Savone. What do you think about this big topic to start with?
Right. Before I start, though, Gene, you and I are going to have a discussion over during reception, because I notice of all the cameras you have, just one of them's a Canon. So.
Well, no, I know, and I was sitting here thinking, the one that I'm most fond of, I left at home, so I'll bring that tomorrow.
Okay. For me, it's the planning of prioritization. How am I going to prioritize what I'm going to file on? And it's a combination of what I'm going to do from an IP standpoint, as well as what is the business unit, because I have to work with the business unit. They're the ones that are paying for it. So if they come to me and tell me I have budget for 2 patents, we then have to figure out which of all of the ideas they have, which of those 2 are going to be the ones that make it worth the investment. So again, it's more of a prioritization, and that's like the first thing that comes to mind.
Yeah, great. So Justin, your preliminary thoughts on this?
Yeah, I think like the other great panelist answers, the big thing is looking at the business objective and the product at issue and how they're what type of IP makes sense to leverage, and it may be multiple types of IP. So I think I kind of fall in the middle that you may hold certain parts of a product as a trade secret, and then you can patent others. So you can kind of a belt and suspenders approach. But it really goes looking at like what is the business trying to do? Is this something that's going to quickly iterate, where we need a patent quickly, or is it going to be something that's going to have more than a 20-year term, where we'll want to have some type of IP that's going to outlast the term of a patent? And then cost is obviously a big factor as well.
Okay, and we'll come back to that, I'm sure. But Michael, your preliminary thoughts?
Sure. So it's a cost-benefit analysis, as my co-panelist said, and unfortunately, I think some of the Supreme Court case law and its progeny after Alice have increased the cost, and also perhaps somewhat mitigated the benefit. So that's one of the things that's factoring into my client's decisions. But one thing that you can do when you're thinking about a trade secret versus patent, that's one of the decisions that our clients are making, is you can just ask ChatGPT. So I put in an invention to ChatGPT and said, should I protect this with trade secret or patent? And it said, I'm a large language model and can't give legal advice. But since you have revealed your invention to me, it is no longer a trade secret. You may want to consider patent protection.
Wow.
So and
that was ChatGPT actually said?
I have to admit, I made that up. But that was, I've seen a couple webinars on the many dangers of actually typing in inventions into ChatGPT, and I know Gene mentioned it, and we'll be talking about it later.
Yeah. No, it was, well, you would hope ChatGPT might be that sentient, I suppose. But all right, so let's dive in, and we can go back and I'll start with you, Louisa, and start with the patent eligibility issue. So when are you really concerned about that issue with respect to what types of inventions, and how has it been affecting your actual filing and acquisition decision making?
Yeah, that's a great question. I mean, I think for us, especially in the software space, we're dealing with a lot of diagnostic tools, and so what we're really thinking about is whether or not what's being entered into or generated by those diagnostic tools is really rising to the level of something that is patent eligible. And one of the things that we also have to consider is that, we're the decision maker in the process, but our faculty are also very involved, and sometimes, having to explain to them that while their invention is valuable, it might not rise to the level of patent eligibility. And the business decision might not be there regardless. It can be a real challenge.
Can I ask you a question about that? Because I know a little bit about Johns Hopkins, and maybe you can share this with others here today and elaborate, but it's my understanding that you have a lot of people that are very interested in getting patents, which is almost unacademic, it seems, And so what is the pressure? Can you explain that part of what goes on at Johns Hopkins?
Yeah, I mean, I think, my experiences specifically at Hopkins, it's largely what I've seen across universities, in that professors, faculty, staff are becoming much more entrepreneurial, because part of their charge as researchers is to get their work out to the public. And I think one of the things that they've seen over the last maybe 15 to 20 years is that publishing does not necessarily get their research into the hands of the members of the public that need the intelligence. And so they've moved into licensing and now even startups, entrepreneurial, endeavors to move that information out to the world. So I wouldn't say that it's unacademic. I would just say that it is a shift in the way that the information is disseminated.
Yeah, I didn't mean to say that it was, like un-American or anything like that, but it seems, I say unacademic in a way because so many universities struggle to really get their faculty interested in the patent system, and all they do is they want to publish.
Mm-hmm.
And I'm going to have to come back to you, maybe not in this panel, but the idea that your inventors understand that the way to get this out to the public is through patents, not just publishing it, is a very astute observation. I mean, because if you can't protect it, you can't own it. And if you can't own it, how can you invest in it? So a lot of really good things and ideas that people come up with that are now not trade secrets, you just can't pursue. Because if you did as a small entity and you started making money, then the giant corporations would just eat you alive.
It's a very careful balance, I think.
Yeah. So Savone, what is your take on this? I mean, I know that you do a lot of cameras, and I will get more Canon cameras, by the way. But do you run into the patent eligibility problem much in your line of?
We do, because I'm actually located in the same building as the main R&D company in the U.S., and they are basically a software application company. So yeah, we do run into the patent eligibility question all the time when we get their invention disclosures, and that's like one of the top things that I look at when we do determine or try to decide what we're going to do and move forward. And we have to have a conversation with the business units, the inventors, the developers, and try to explain to them, great idea, like you were saying, it's a great idea, product-wise great, but the chances of getting a patent maybe not so great. And then we have to remind them that 18 months after we file, the rest of the world is going to know exactly what you're doing, and you may not be able to protect it, and there might then be an impact on market share. So it is something that we do have to consider very closely, again, in terms from a budget standpoint, but also, do we want to tell everybody what we're doing, and we may not be able to protect that.
Yeah, so where do you generally, is there a side that you generally come down on?
Typically, it's, we recommend a course of action, but again, because the business unit's the one that's funding it, it's kind of their call. And if they want to move forward, we'll go ahead and do it for them. But typically, we do try to move forward and file what we feel that we're comfortable filing in terms of what we think we're going to be able to get.
So you guys like patents?
We do.
Yeah, and
As
you guys,
can
if
tell.
I'm correct, you're usually in the top 10 and sometimes in the top 5.
Canon over the last 30 years has been in the top 5. Yes.
Yeah.
Yeah.
Yeah, right at usually number 4 or 5.
Yeah, we usually would have been number 3. We dipped to like 4 or 5 last year.
Yeah.
But yeah, we're typically top 5.
So how many patents is that? I mean, are you getting a year to be there?
We are, and this is, the majority of them are from Canon Inc., our parent company in Japan. But typically we're in the neighborhood of around 3,000 a year, give or take.
Yeah.
Yeah.
Yeah, so Canon likes patents.
They do,
Yeah.
yes.
Yeah, good.
For example, if you take a DSLR,
Yeah.
there's about 3,000 patents that are potentially applicable to a single camera.
Yeah, we're gonna have to do a podcast on cameras, I think. 'Cause I'm an amateur photographer, and it's fascinating, all the cameras. The one thing I also think is an aside that is fascinating, and maybe this does fit into what we're talking about here, is the company that invented the digital camera now no longer exists, really. I mean, Kodak was so in love with film that everybody else makes money on the digital camera now. which I think is an interesting, because they patented it, but then they didn't do anything with it. So that's another question. We're talking now whether you should be getting patents in the first place, but if you get them, then for God's sakes, do something smart with them, right?
Yeah.
So,
Could I,
Michael, it looks
could I
like
ask
you want to
Sivan?
say.
Yeah, I was curious. Where does Canon focus their enforcement?
Typically, we're going to do it where there's money, and that's basically in the toner cartridge area. We're very aggressive in terms of bringing suits. In fact, we go to the ITC quite a bit to prohibit importing toner cartridges. Yeah, Japanese companies are not very litigious amongst themselves. The majority of litigation we get involved with, we're the defendant.
Yeah. But you would use the ITC.
We will use the ITC. We've gotten some presidential decisions at the ITC based on, again, it was mostly toner cartridges.
Yeah, which is where there's an awful lot of money.
Yep.
So Justin, what is Capital One doing in this space? What kind of patents do you guys normally go after, if there is a normal, and how impacted have you guys been with respect to some of the patent eligibility decisions?
Yeah, so we deal a lot with software. I mean, outside of we have some cafes, physical retail banks, and now airport lounges as well. But outside of those, like typically where you're looking at software primarily, so we're highly affected by 101. And that can be back-end software to optimize how things run, and machine learning to enable new customer features. So 101's obviously always at the forefront. A lot of times, my feedback when working with inventors is to figure out, I know what we're doing, but like we can't merely, if you're just telling me you're substituting machine learning algorithm for like human mental decision making, that's not going to be enough for us to move forward. So trying to poke under the hood more, and then also get our outside counsel as well to do the same. Typically, when that's kind of like my litmus test is, if you're not telling me more than saying if you could substitute the human for what the computer's doing in your description of the invention, it's going to be an uphill battle probably before the patent office. So that's one of my kind of tools. One of the big things that I think is valuable from the balancing the trade secret standpoint is, even if you disclose an algorithm, there is a lot of value in the underlying data because you'll need to train a model. And that's one area being digital first, one of the early fintechs and digital first financial service providers, having a large trove of data has been very beneficial for that as well. So that's kind of a good area to balance. I think you have, ideally, in an ideal situation, you're patenting like a detectable user-facing feature, and then you kind of have your belt and suspenders approach with maybe some type of like quasi-detectable machine learning being patented as well. And then the data obviously is retained as a trade secret, or parts of the algorithm as well. So that's kind of like an ideal situation, but it obviously depends on the facts of the given feature and how much is new and what part is really
Right.
like revolutionary.
Yeah, talking about some of this in the abstract is a little bit difficult, but I was just wondering, do you get a lot of 101 rejections?
Yeah.
I mean, everybody does, right? Everybody.
Yeah. I mean, part of it is
Today, if a garage door gets a 101 rejection, I'm pretty sure everybody's getting them.
or a axle.
Right.
But I think a lot of it is upfront, really looking at the invention and framing it and telling the story about what the advancement is. If you're talking off the bat, like I have this new travel feature, and the problem before is that it's time consuming and difficult for a consumer to figure out what activities they want to do when they go to Paris. Like, you're setting it up to be automating a manual human process and just throwing, the 101 rejection on a platter to the examiner to be like, okay, here you go. But if you're actually looking at the problem is being able to query mass amounts of data, being able to, automatically identify trends in data, Well, that one might not be so great. But if you're looking at,
Well, no, it's great. It's just the patent office
Yeah,
can't
yeah.
give patents on it, right?
Yeah. So, but you're looking at what the computer's doing and the technical problem. One of the things that when I was in private practice, I got to spend a month working out of an office in Europe, supporting EPO prosecution, and their kind of technical effect. It really was helpful, and this was post Alice, but still it helps like reiterate
Right.
because even in their kind of obviousness inquiry, you have to show that what you're adding that's different over your primary reference has a technical effect. So they kind of have a mismatch of 101 with their 103 analysis. And so taking that approach in the US, I think, is like helpful for satisfying 101.
Yeah. I think I'm surprised that it hasn't happened already, but I keep thinking that the U.S. is going to adopt the European approach. I mean, it just kind of makes sense. It seems like some of the Federal Circuit decisions want us to go there, define the technical problem, define your technical solution, and then, Hakuna Matata, everything's going to work out okay. And for folks like you all that are filing, well, let me not assume. I assume you are filing overseas as well. I know Canon does,
Yep.
right? Does Johns Hopkins file overseas?
We do very strategically. If we have a licensee, they definitely drive that process, and if they have business overseas, we will certainly file. Using the crystal ball method, we do file on some of our unlicensed cases as well, but it's much more rare.
Okay. And then, Savon, you guys file everywhere, right?
Yeah, I mean, it's, we file in the major markets, and also depending on what product it is and where we think that product is going to be, hit the market, yes.
Right. So, and I ask this because, well, I want to put a pin in this because I want to get what Michael's thoughts on something Justin raised, but I want to put a pin in how does the filing overseas, in the market overseas, and the ability to get patents, some better and stronger in other countries, factor into whether you keep it as a trade secret globally, or whether you move forward even knowing that, well, maybe we won't get protection in the U.S. So if you three could think about that for a minute. And Michael, I want to come back to you because Randy tells me not to put you on the spot or to put Randy on the spot. And I keep referring to Randy. Randy is the Chief Patent Counsel for Cigna, and he'll be on a panel here in a minute. But Randy tells me that you have some very thoughtful ways to get around 101.
That's nice of him to say.
So what do you do? Like if somebody comes to you and says, like, we have this invention, we have something we'd like to move forward, and they ask you, do we move forward, do we not move forward? How do you decide whether the creative arguments that you've come up with to convince examiners are going to work in this case, or whether this is really just, you can't let anybody know about this because it won't get protected and you'll lose it?
Yeah, I mean, I try to give people advice about what I think the options are and how likely they are to make it through the patent office. And I think one of the more painful discussions is, and you might get a patent, but please don't enforce it, because that's where you're really going to find out the true pain of Alice. But I mean, just like my co-panelists, there's a number of techniques you can use when drafting the application and also when prosecuting to make it not sound like you just have a human who's been pulled out of the loop and thrown a computer in there with some generic machine learning. One thing, when I learned how to write patent applications 20 years ago, I was taught, make sure you explain how the invention works. Don't have a bunch of self-serving statements about how great it is, how amazing it is. And that's something that I think maybe other people changed their practice earlier than I did, but in response to Alice, I realized, oh my goodness, we need to have some self-serving statements in here. There's a number of cases like EnFish where there's statements about how fast the search can occur in a database because of your amazing invention. And courts and examiners sometimes rely on those completely self-serving statements, often unsubstantiated and occasionally not even true. So that's something that I've learned, that when you're writing a patent application, you can talk about all of the amazing ways in which your invention makes it faster, uses less memory footprint, et cetera. And I've had examiners want to point to portions of the specification to say, oh, I see the advantage, okay, fine, we can get over the 101.
Yeah, and it seems to me that the whole point of NFISH in a lot of these cases was if you're not making these self-serving, aggrandizing statements in your application, then why are you even here? If this is not better, stronger, faster, which all those things have always been historically patentable. And if you can't describe in your specification when you get all the ink that you want, even the most basic way how your invention is better, stronger, faster, then it's not eligible. That's what it seems like to me. And I do think the Patent Office looks at it that way. I'm not sure that the courts have yet figured out that to get past 101, it's a pretty low, should be a pretty low threshold. But I guess my question then becomes, how do you do that? And Michael, back to you. How do you do that in a way that doesn't destroy the application for KSR purposes? When you describe too much too well about what's wrong and how yours is better, stronger, faster, examiners can then say, oh, well, that's predictable. It was just the next step. Because I think that KSR created an awful lot of mischief with drafting that a lot of people are living through with 101 issues. Would you agree with that? And how do you draft?
Yeah, so I've certainly learned to be more careful about your background, whether you put that in the background section or the detailed description section. Often what your inventors see as background is actually something that they've really come up with themselves from the art. When I've taught patent drafting to new associates, one of the things that I think is very important is to not frame the problem so well that the solution becomes immediately apparent, and especially don't do that in the background section. Because, yeah, if you can describe the problem simply enough and straightforwardly enough in the background, then all of a sudden, yeah, it does sound quite obvious to use whatever the solution is.
Yeah, yeah. So, Justin, I see you're thinking there.
I was just gonna say, one of the things I try to encourage outside counsel to do is that the problem may be something the inventors discovered, so that can be part of the invention as well.
Absolutely.
Yeah. So, Siobhan, thoughts on this? How do you draft to get around the problem?
I mean, I try to keep and have my attorneys try to keep the background as simplistic as possible, just very brief, just, hey, this is what the issue is, and then maybe talk about what is needed and what's missing, and but in the detailed description, go into as much detail as possible as with respect to not only the invention, but also, what's the benefit, what's different, what am I doing here that's not out there?
And how much ink do you spend on that? And I'd like to ask Justin as well. Like, what's your preference when outside counsel? Is it like, because Microsoft, I believe, has had very famously a word count for the background. After KSR, you can't have more words than this in your background. So how much ink do you want to spend trying to NFISH proof, not NFISH proof, but NFISH eyes your application so that you can say, oh, this is different?
Yeah. I mean, I've seen backgrounds, not that we do, but I've seen backgrounds that are like, 30 paragraphs long. And I was like, I can't do that. So I try to keep it, we don't have a specific paragraph count, but it's kind of like one of those, you know it when you see it. So typically, if I had to make a guess, I would say to try to keep it to under 10 paragraphs, because to me, I don't need a whole dissertation on what the background is and what,
Right.
I think you can just be very concise, get to the point of what the issue is, because sometimes you say too much. And if you say too much in the background, sometimes you'll get applicants submitted prior art as a rejection because I said too much in the background.
Right, no, absolutely. And I think that's where a lot of these problems came from. People don't want to say anything. You do read, and this was a problem even, I think, before KSR, but certainly after KSR, you'd read applications, and I read a whole bunch of these things over the years, probably more than most. And I get to the end, and I'm like, I have no idea what the inventor or patent attorney thought was innovative. I mean, there's probably something there, you know, but unless you've done the prior art research and you've been involved in the R&D, for so many patents, you get to the end and it's like, okay, so what? Where here is the unique thing? And years ago, it would have been blasphemy to talk about the point of novelty. But I think that's where we're at, right? So, would you agree?
I do. In fact, when I get invention disclosures in from the business units, if they don't have what the current state of the art is and what their advantage is, and it's not clear, I kick the invention disclosure back to them and force them to no, you got to fill in you need more than 2 sentences to describe what your advantage is.
So that's why you get so many patents, because you do it right. I mean, because a lot of us, and we were joking around at dinner last night in our conversation, who's the inventor?
Yes.
You know, and that's how you make sure your attorneys aren't the inventors, is you kick back the disclosures.
Yes.
But if you don't work for a company that's willing to kick back the disclosure, I think a lot of times the inventor is the patent attorney, because you get like a paragraph or two. And it's like, how am I going to turn this into a 50-page application with drawings and claims?
Right.
You gave me 2 paragraphs that don't say anything.
Yeah, and obviously I'm not very popular sometimes when I do that, and I've got I have a little nickname that they've given me because a lot of times.
Can you share the nickname?
Well, no, it's we have a memorandum of invention. MOI is what we do. So my nickname is the MOI killer because in a lot of times I'll get an because I'll get an MOI in, and within 5-10 minutes I've done a search because it's not detailed in terms of what the advantage is. I'm able to find something out there that is almost on point or very close to it, so I send it back and say, give me more.
So if you were a UFC fighter, that would be a great nickname, the killer.
The moi killer, French.
Yeah. So Justin, let me get your thoughts on this too. From the Capital One perspective, I mean, what kind of disclosures do you get? Do you think like you get enough? How does that process work to make sure that you're able to hopefully write an application that would satisfy the NFISH standard?
Yeah, we don't have like a firm policy around the background or the length of it. I think personally, I generally, if the inventor is providing commentary about the state of the art, like I encourage that to move out of the background section just to avoid any presumption that that's somehow part of the, quote unquote prior art. So generally, personally, I say like shorten the background section and then don't shy away from talking about and critiquing or discussing, contrasting, the state of the art with the advancement described, but do that as part of the detailed description to make sure that it's clear that that information is coming from the inventor and is part of the invention story and things they contributed. Yeah.
Okay, so Louisa, I want to get your thoughts too from the university perspective. You get disclosures, I know, from all over. How do you try and deal with the disclosure issue to make sure you get enough so that the attorneys can focus on what they need to focus on?
So I think this is something that our team does extraordinarily well. We have intellectual property managers that go out and meet with our faculty that submit disclosures, and they really challenge them to tell the story, to explain the issue, and to kind of help us see where, maybe a product would be directed, where the novelty is from a patent perspective, certainly. And so we do a lot of pushback too. I mean, we can joke about being MOI killers or disclosure killers, but I think that when we do provide that pushback, we get much, much better disclosures. We get much better patents in the end.
So one of the topics for, I think it's the next panel, we're going to dive into culture a little bit, and creating an innovation culture. So let me, not to steal their thunder, but I would love to get your thoughts on that. How did you, because when you get pushback, are they upset? Because it's my understanding that at Johns Hopkins, people really want patents. And so what's the culture there in terms of when you give pushback, we need more? Are they willing to work with you?
Yeah, I mean, I think there's always going to be folks who are upset by that sort of feedback. You know, no one wants to hear that something is missing from their invention or their disclosure. But I mean, I think delivery is everything. I think that, you know, being gentle and constructive is definitely helpful in this context. I mean, we certainly don't go in and just say, no, this is terrible. You know, why are you, you know, why have you spent the last 20 years of your
Your
career
baby is ugly.
pursuing this, right? You know, we try to, you know, help guide them, help, you know, see perhaps where they need to go. And I think on the whole, in the end, they're usually grateful for that advice because they, you know, they have something that's stronger in the end, either from a licensing perspective or a startup perspective.
So, Siobhan, is your culture the same? If your nickname is Killer, my guess is that the culture may be a little different.
No, our culture is, you know, IP is very important, obviously, and that comes from, you know, Canon Inc. To its various subsidiaries, and you know, each of the business units are aware that patents are important, and we have enough of an exchange with them that we've gone through a number of training programs with them, so they understand what's needed. And in some cases, we have some inventors that we have gone straight from invention disclosure to patent application with very little massaging needed, just because they get it. Those that haven't got it yet or need a little more training, they understand when we push back, because we explain to them, as you were saying. I just don't send back and say this is horrible. It's, hey, good idea, but I need X, Y, and Z in order for me to be able to move forward and try to get you the patent. And they're understanding of that.
Yeah. So, Michael, are your clients understanding? What?
I have to admit,
And not to throw Randy under the bus, but he gives you good stuff, right? I mean, he gives you plenty of information.
Excellent.
So, and maybe we could start there with this question: is that what kind of working relationship do you really want or need in order to make sure that you get what you need, knowing that some of these hurdles are going to be quite high?
Yeah, I think Justin mentioned this. You need to make sure you're looking at the technical aspects of the disclosure. Some inventors are quite fixated on how much money they're saving the company. You know, there was an inventor from a client I will not name, but they said, well, hey, we're moving this off of a AWS platform that's costing us a lot of money, and here's the solution we came up with. And they wanted to tell me how great the business case was. And I was trying to redirect them into, okay, let's talk about the technology. And so you have to have a very gentle touch to make sure that you're not poo-pooing the cost savings and focusing on the technology. As Justin said, we try to do a good job of characterizing the invention in its technical terms. So instead of a claim talking about a risk assessment, we talk about some sort of database-derived metric, and using those different terms. Sometimes art unit predictors help you to help your intuition as to which terms are going to cause problems. But if you can get in front of the database art units rather than 3,600, you have a much better chance of getting searches rather than just 101 copy paste from their from their template.
Yeah, and that's the interesting thing is how the applications get characterized and where they get routed within the patent office, because that matters dramatically. I mean, but
yes.
So, if there's any questions in the audience, Siobhan, if you see anybody's hand out and you want to call on them, please join the conversation. But
I wanted to ask Louisa, how do you keep your computer science professors so excited about the patent system?
Well, I think that in the computer space, we have a bit of a split. So we have our School of Medicine faculty that are, very entrepreneurial. And, I think as we've all probably seen, in the last several years, everything has some sort of computer component attached to it. So a lot of that software is kind of tangential associated with a device, with imaging, with, some other hospital-related, medical, diagnostic-related system. So a lot of our software comes from that space. Our computer science faculty, traditional computer science faculty, I think are much more reluctant. And I think, that comes from the fact that their space moves very quickly. We've spoken to computer science faculty who, tell us that, like, by the time they release a snippet of code, within the next week or two, it's kind of passé, right, in their field. And so they're really operating on a different time schedule. They're operating with a completely different philosophy. A lot of their stuff goes out on GitHub. And it's disseminated in a different way. And I think that, another one of our challenges has been to, recognize those differences between the ways that these faculty operate and, helping to guide them so that, something isn't just sitting on GitHub, looked at, unused. And so, yeah, I think that's another one of our big challenges. And, whether the software coming out of computer science is patentable or not, I think it's really our goal to work with them so that they feel comfortable with the path that's being taken.
So I don't understand how, like, in a couple weeks, code could become passé. And I would think if that is actually true, then there was nothing particularly innovative about that code, I would think. Or unless
maybe
what you're being...
passé is the wrong word, but I would say that it's already moved on. They've taken that idea and they've iterated it 10 more steps, and it's now evolved into something different.
So let me ask you this question then, follow up. What level of problem is open source? Because the one thing that you always worry, this comes up with AI, which we were just talking about. You don't ever know what the AI is actually giving you. Is it giving you your own stuff? Is it a mirror? Is it using, somebody from your competitor company trained it inadvertently with some stuff that now you're using?
Or is it all just Stack Exchange?
Right. So, but the question becomes also from open source is you take this little piece of code and now you are, it's like literally a deal with the devil, and sometimes it's not a bad deal with the devil because you're doing it knowingly. But at times, from your perspective, I would think, it could be a deal with the devil because they don't even know or appreciate what they've done. Mm-hmm. So could you comment on that? Yeah,
that's another very big challenge. I think especially for us because what we're trying to do is build commercial partnerships with outside companies, and so we have to have some sort of IP or product to deliver to them that we can put boundaries around. But I think that the way that we've been thinking about open source is that for those faculty that choose to work in that space, it's another means of dissemination. So we don't really see it as something terribly different than a publication in, say, Nature or Science. And to be honest, a lot of them, in the university setting, a lot of this research is being done with federal funds, and there are criteria, requirements with that money that say that, this work needs to be disseminated on GitHub, it needs to be published, there are rules. And so part of it is, just complying with that sort of research ethos. And what we really try to do is then ask the faculty who do work in that open source space, whether there are add-ons, whether there is a potential business model that could be useful in getting that work out to people who may be more traditional clients of technology transfer.
Yeah. So Siobhan, do you have that same issue at all? I mean, do you guys do much code or software patenting? I know you do a lot of ink cartridges. You obviously do a lot of cameras.
Yeah, we do software patenting. Yes.
So how much of a problem do you think the open source presents? Are you worried that they're relying on stuff or taking stuff from open source networks?
I mean, I do, and that's, before we move forward, I always make sure that I get a good understanding of what did you do, and if you did use open source, what did you use it for? For example, if you have your application to control the shutter speed for the camera, for example, the functionality of that is, did you guys develop that, or is that something you use the open source for? And depending on the answer, it's like, well, we can file, or no, we're not going to file. So it does depend on that, and we do have those detailed discussions with the inventors.
So let me take the next step. Do you have those same kind of detailed discussions that we're dealing with open source, dealing with AI, or has it not yet come up?
It hasn't come up yet, but I would have the same exact conversation to see, from what you developed, did you use AI to develop any of it, and if you did, what? So yes, it would be basically from a high level conversation. It would be an identical conversation, maybe different nuances depending on whether it's open source or AI, but same concept.
Yeah, and you may or may not file depending on the answer.
Yeah, I mean, ethically, if somebody tells me, yeah, that function is being done by open source, like, well, what am I going to file then?
Right.
It's not your invention.
Right. No. Exactly. So Justin, what kind of do you have these same type of conversations with your inventors, and how does Capital One handle it? And maybe I will come back to you, Siobhan, and ask you this. So Justin, the question I have: has Capital One taken the Apple Samsung approach yet with AI and told people don't use it?
I'd say we're taking like a cautious exploration of the AI space. In the open source, so there are a number of problems, kind of. I think one is there's, current pending litigation involving GitHub Copilot with a number of, I don't know if it's a class action lawsuit or just particular copyright holders. But the question of whether training a model using copyrighted material is permissible. But also then there's the issue that regardless of how it's trained, if it produces verbatim copyrighted material and you're using that, then are you infringing the copyright? So those are some issues, like I think that companies need to kind of work through to figure out what risk measures to put in place to make sure if you're using these like code generation tools, how you can do so in a safe manner to minimize IP risk there. Separate from that is when you're talking with inventors, identifying what open source they're leveraging or what, if they've used AI to assist as a tool in developing the invention. And I think just understanding, this is probably a boring answer, but understanding how that was used and in what way it was used when they, reduced the invention to practice is good to just understand. A lot of times people, in probing too, I think one of the questions when I talk to people is when they mention something, I'm like, okay, so using, maybe this is an open source tool you're using, is that it? Like, are you doing more than how someone would normally use this? If so, like, what's the difference? Why is that not foreseeable to your peers? Because an amalgamation of like a number of disparate open source tools could form the basis of an invention. Or just using one single open source tool in a new way could also potentially be one.
Yeah.
So, but really just understanding,
Yeah. That makes sense. But Siobhan,
Well,
back to you.
You have
real-
a question?
Okay.
Sorry. There was a question?
When you guys use open source, do you worry about the licenses that go with it and the ownership that can sometimes bring to that open source community of the whole software?
Yeah, so we have I think a lot of companies do, but open source license compliance regime, so that you're only using licenses that have terms that are compatible with your business objectives, basically. So you're not getting some of those licenses that, could basically force you to make your code publicly available, or, grant unintended licenses to your patent portfolio.
Yeah, we have the same approach in terms of reviewing the licenses and using only those that are compatible, for lack of a better term.
So what about AI? Are you discouraging use of AI like Apple and Samsung?
We've got, it's as Justin kind of what he's saying with his company, we're doing the same thing. There's like an internal evaluation going through in terms of, what you should and shouldn't do. Luckily, from use of it, from coming up with invention, things like that, the developers who would be using it know the dangers of it, and we've had conversations, so they know on their own to stay away from it for right now until something better comes along. So I'm pretty confident that the developers are staying away from it on their own, just because they understand what the dangers are.
I'm smirking at you, and are you really comfortable?
I am, just because I've worked with some of them for 15, 20
Okay.
years.
All right, so it's a trust thing.
Yeah, it's a trust thing. It's like I said, some of them I've dealt, and even their management, I've worked with them for 15, 20 years. That they get it and they understand. And yeah, I am comfortable. If they were more junior in terms of, hey, this is cool, let me go use it, I would not be so comfortable.
Right. Yeah, I would think not. Yeah. So Michael, let's come back to you. One of the things that we said in the description that we might touch on are decisions made in light of licensing realities. And clients are just not getting licenses from a lot of the big players, like Apple and Samsung. There's always litigation that seems to be necessary, and not to single out them. It's a lot of people that are doing that. So how does that factor into the advice that you give clients? Like, somebody comes to you and tells you, oh, hey, I got an invention that Google's going to need to use, or it fits with Facebook, or these companies that it's going to be virtually impossible to get a deal unless you have a real substantial portfolio. And even then, it's tough. So how does that conversation go, and what kind of advice do you give in light of the licensing realities?
I think, depending on the sophistication of the client, you have to remind them that there is no patent police. So once you have your patent, there is no enforcement arm that just goes out there and stops people from stealing your idea. But certainly, even for more sophisticated companies, if they say, well, we filed a patent application, so it's protected. I don't have to tell everyone here that that is not protected. And also, it's I think even for some more sophisticated engineers, they don't appreciate that just because they've described it in an application, that doesn't mean all of the ideas there are protected. So if you have a single patent that covers Gmail, you're probably not going to get very far with Google. If you've got a portfolio of 60 or 70, then I don't know, maybe they would actually talk to you at that point. Because each IPR, you're looking more at $300,000, and all it takes is one claim from one patent to make it an expensive problem.
Yeah, and this number changes a little bit, but I've heard that you probably need to have 30 or more infringed assets. And at that point, then the math works out in favor of taking a life. But to have 30 infringed assets of any quality, I mean, your portfolio would have to be at least, I would think, 300 patents at least. And that's sort of the problem. I mean, Sivan, you're smiling. What is your analysis? Is this why Canon is getting 3,000 patents a year?
Yeah, I mean, yes. It's part of it is we want to build up as robust a portfolio for various reasons. You want to obviously protect the product that's out there, but you also want to have some in your back pocket if necessary for potential cross licensing moving forward. And also in some cases, I may want to use one of my patents to try to invalidate somebody who's bringing a lawsuit against us. I may use some of our patents to try to invalidate the patent that's being asserted against us.
Yeah. So, Louisa, you guys, by definition, license. I mean, the university's not. So what kind of portfolios are you having luck with? I mean, because the independent people who aren't in universities, you have one patent or a couple patents, they're getting nowhere. But is that same true for the university model?
I think it really depends on the space that you're in within the university, because universities, by definition, have such a broad base of technologies. We see movement in different areas, and it can change year to year. Sometimes there's longer cycles. And I think we find more success when we do have at least a small portfolio built around a technology, or especially in the non-pharmaceutical spaces, if we're able to spin out a startup, and that startup is able to further develop the technology. I mean, I don't. I don't see a lot of movement of licensing one patent to Google. It's just not something that anyone is doing, whether they're a university or a small startup.
Right.
So.
Okay. Well, I'm looking at the clock, and we've gone through almost an hour. But what I'd like to do is give each of you the opportunity to give your final thoughts. And Louisa, since we're already with you, maybe I'll ask you. Hopefully, and the question is always the same when I wrap up. It's hopefully the audience will remember more than one thing. But if they only remember one thing from this conversation, what do you hope that is?
I think it would really be to have the most robust conversation possible you can with your inventors. If there's more than one, try to include the entire group. I think you generally find a lot of nuggets of valuable information if it's, for telling the story about the invention, the problem, why the solution matters. Having that robust conversation is I think, one of the most important things that we can do as patent practitioners. Have we AI-proofed our jobs yet? I mean, I feel like this is very complicated. Right?
Yeah, no kidding. All right, well, thank you very much, Louisa. Sivan.
I would probably say just maybe, if you're dealing with a client who has budgetary constraints, just, try to collaborate and figure out what's the aspect from an IP standpoint, where is the priority from an IP standpoint, as well as what the priority is from the client, and just to try to understand what exactly the client wants to protect. And then, like I said, just you have to have a collaboration between the attorneys and the business units.
Okay, great, thank you. Justin, your final thoughts here.
I would just say, think about the business objective and then craft the IP around that. I think trade secrets, patents, open source, all of other forms of IP we're not touching on, all can support that, and knowing what role each one is going to play. And patents might not always be the star. Sometimes they are.
That's blasphemy. That's blasphemy. Patents are always the star.
But when they can be, it's great. But just knowing, and even if they're not the star, they have a role.
Good catch. Good
So.
Good save in a room full of patents.
But just knowing that, and I think when I get feedback from outside counsel that's candid in that regard, not forcing their services on us,
And I'm
get
just giving
more
you a hard time
credibility.
because I agree. I mean, you have to let the innovation speak to you, and sometimes it's a trade secret, and sometimes it's a patent, and sometimes it should be a patent, but as we know, as we talked about here, it can't be because of a variety of reasons, including 101, primarily right now. So it takes so I just gave you a hard time. But your answer was, I thought, perfect. But
Okay.
I couldn't pass it up. So
no.
So thank you, Justin. And Michael, I'll give you the final word here. What do you hope people remember?
So instead of summing up anything any of us have said, I thought I'd mention something we talked about before, that simply not filing a patent application doesn't magically turn your invention into a trade secret. So that's something to keep in mind, especially for some of the newer companies, that you need to actually protect your trade secrets, not just simply fail to file patent applications.
Yeah, I like that. That's great. I'm gonna steal that, I think, because I always used to tell people when I'm doing trade secret litigation, in one case in particular, the other side was claiming, oh, this is a trade secret, making a big deal about it. And I'm like, tell me one thing, just one thing that you have done to keep this secret. And they couldn't come up with one thing. So, I argued to the judge, if they can't even come up with one thing, then it can't possibly be a trade secret, just because they want it to be. So that's, I think, great advice. Thank you very much for being here. And thank you all for coming to our event here today. But that brings us to the end of that CLE hour. So if you need CLE, make sure you signed in with Renee, and we'll keep track of it for you in case the ethics police come calling. But
If you didn't get
thank
a
you.
survey, I have extras, let me know and I'll give you a survey as well. And even if you don't want CLE, we do want to do the surveys as well.
Okay, great. Thank you, guys.
Thanks,
So-
Steve.
Thank you.